represent Ms. Kate.
Remember what? Would you repeat that again?
Americans for Safe Access,
Okay.
San Diego.
Sure, I understand.
And Kate Valentine provided this to us. You'll see the green on our map is a little bit different than your map, and that green shows the areas that don't include a 1,000-foot buffer from not just current residential establishments, but residential zones. And I believe the inconsistencies that have been presented to you in every staff report since the beginning of medical marijuana.
That's right.
The inconsistencies exist in the map that you see on the board today. Not on ours, but on theirs. Our map shows green spots before you add in 1,000 foot from each residential zoning. And if you add in zoning, we come to about 25 square feet in the county. Now, I would also like to urge you to understand that all of these erroneous laundry lists of sensitive uses are coming from a white paper that is not middle of the road, gentlemen. It's far, far right. It has a far right element that you are well aware of. There is a far left element that you're aware of.
Your time is up, but
I will wind it up.
hold on one
Yes, sir.
moment. I, in particular, you're saying some important things,
Yes, sir.
especially the land use. How much time would you need to?
One more minute, if I could.
Fine, please.
Thank you. With regard to land use, I'm sorry.
Take your time.
White paper.
Thank you. With regard to the white paper, it's referring to things that have happened which are giving you reason to put these unnecessary restrictions on medical marijuana dispensaries in this county. Now, if you were to look at the more current, more up-to-date reports from the really important reports from the chief of Los Angeles, who has 1,000 dispensaries. He is the foremost authority on dispensaries in California. And that man did a report that showed not only did crime not go up, crime went down where dispensaries are located. Oakland is, you don't want to hear about it. Everybody frowns when they hear about Oakland, probably because, well, we won't go there, but they frown. Well, the area that they put those concentrated, where dispensaries are next door to each other, that was one of the worst areas in Oakland. It is now one of the best.
Yep.
Places that have regulated them, like Oakland, as Marcus mentioned, and other cities that have actually established regulations, they've seen a significant decrease in crime. I urge you to adopt the sensible, legal, and constitutional regulation, because if you don't, I think that many patients will be without safe access, and there will be a lot of very unhappy voters in this community that I believe will let their opinions be known the next election. So I urge you, please, adopt a sensible regulation. And many cities in the county are looking to you for that legal route to that. Thank you.
Thank you.
Mr. Chairman, that concludes the public speakers.
And we can add to that list of the area we're responsible for was Boney's. Okay. I decided to do this a little different than we normally do, rather than us deliberate on it right now. And thanks to you, you brought up a lot of information over and above what we have. In particular, County Council, Mr. Silva, I guess it was, talked a lot about the law and 15061B and those kinds of things. So I like for staff, including County Council, to help us by delving into this before we get it. And that'll help, I think, give us a better point of view from you commenting on what you've heard. Thank you.
Mr. Chairman, Tom Button is here today from County Council. He worked on the case, and I'd like to take advantage of him while we can, because he has to run off to court very soon.
I'm glad I'm doing it this way then.
Thank you, Chairman Brooks. Actually, I've got a response to 3 of the legal issues that were raised here, and I think I've got enough to make both sides unhappy with what I'm going to say to you. So I guess I'm doing my job.
But you're not running for office, so that's
The first issue, of course, is the statutory provision that's been raised as far as a board or a local entity not doing anything or passing any ordinance that violates either state or federal law. and there was a reference to a Superior Court decision out of Lake Forest deciding that matter. Of course, Superior Court decisions aren't binding precedent. We leave that to the Court of Appeal, and I would imagine that this issue is going to go up to the Court of Appeal and potentially the California Supreme Court as well. It would be my analysis under that situation that, and there's a body of law that says if you've got a real specific law dealing with a specific subject, that if there's a conflict between that and a more general law, that the specific one dealing with the specific subject controls. And here's how I think it plays out here. We've got a situation where under the state law, cooperatives are allowed. The Attorney General's guidelines have come out interpreting state law and said they are allowed. If every jurisdiction within California were to be bound by this general provision that says you can't do anything that violates federal law, then they all could ban cooperatives. And therefore you would be in a situation where state law, the specific state law saying they're allowed, wouldn't be able to be followed. So if the courts get this, it is my assumption they're going to follow that provision that says the specific controls over the general, and therefore the legislature could not have intended when they passed SB 420 or when the initiative process was enacted in 215 to allow an outright ban on legal cooperatives. Right. So that's my analysis with respect to that issue. My analysis with respect to the ADA issue, and someone raised this to say that these restrictions would violate the federal Americans with Disability Act, is largely the same analysis there. Under federal law, there is no medically accepted use for marijuana. There is no ability to obtain it legally under federal law. The American Disabilities Act, and that was part of the Federal Controlled Substances Act. The American Disabilities Act came later. When Congress enacted the Americans with Disability Act, they knew under federal law that marijuana was not legal and was not available. So therefore, there could be no congressional intent in passing the Americans with Disability Act to allow individuals or groups to use that as a method of saying restrictions on marijuana access are somehow illegal, because Congress knew when they passed the ADA that it was absolutely illegal under federal law and still is now. The third issue I think that's been raised, the primary legal issue, is the signage issue. And while time, place, and manner restrictions are certainly allowed with respect to signage, you cannot signal out particular regulations or particular signage based upon the content of the speech. And commercial advertising under Supreme Court precedent at least is considered some form of speech. It may not rise to the level of political speech like we've been listening to today, but it does and is entitled to some form of protection. And so there cannot be generally content-based restrictions. So if you're going to make a signage requirement that only applies to advertising of marijuana, I believe that's a content-based restriction that would violate the First Amendment. If it's across the board restriction that applies to all commercial speech, no matter what the product or issue, then that I believe is okay. But I think the signage requirement here, at least as it was originally written, wasn't an across-the-board provision and was directed directly at marijuana. So I think I've said enough to make both sides happy and I'm happy.
Commissioner